hand it to you, Aurélien, to present our speakers.
Great. Thank you so much, Nicola. I'm very thrilled to be moderating this great panel on FTC rulemaking authority, and especially when it comes to unfair method of competition. So, and of course, encourage everybody to read the book, where a lot of articles are truly amazing and very interesting in the current debate. So when President Wilson in 1912 had this idea of creating a Federal Trade Commission, one of the main goals of the Federal Trade Commission was first to be an aid to the Department of Justice Antitrust Division, to help the division in terms of enforcement activities. Was also the idea to create an expert agency where you gather a lot of experts on consumer protection and competition in order to have a better knowledge of what's going on in the market and perhaps to better regulate the behaviors of firms. And so the idea of this expert agency was to also issue some reports and draft guidelines and to gather information, to share information with the business community in order to increase so-called the legal certainty. And for example, well, the sections we're going to talk about, section 6G, say that the FTC should classify corporations. So there's this very, very complicated exercise of information collecting, information sharing. But more controversially, there's one aspect of the FTC which is still under discussion. And this aspect is the ability of the FTC to make rules. Not necessarily interpretative rules, but some sort of legislative rules. So the question is, does the FTC has rulemaking authority? And perhaps the answer differs whether we discuss the two main activities of the FTC, whether it refers to consumer protection or whether it refers to competition. And so I'm very delighted to have this panel because we are going to try to decipher and answer these questions, whether or not the FTC has rulemaking authority when it comes to so-called unfair method of competition, and whether they had, well, what we can do and what we should be doing, or what we shouldn't be doing, at least when it comes to a rulemaking authority for unfair method of competition. The panelists you have here have written extensively on the rulemaking authority, and it's a great pleasure to have them sharing their expertise on this topic. So on my very immediate left, which doesn't mean anything politically, we have Alden Abbott, who is the Senior Research Fellow from Mercatus Center of George Mason University. Alden was a former General Counsel of the Federal Trade Commission. Then we have Maureen Ohlausen. Maureen is a well-known author and enforcer. She was former Federal Trade Commission chair. She's now partner at Baker Botts, the law firm, and co-chair of the competition practice. Then we have Marina Lau. Marina is professor of law at Seton University School of Law in New Jersey. And then finally, we have Richard Pearce. Richard Pearce is a professor of law at George Washington University. So without further ado, let's kick off the discussion on why are we talking about FTC rulemaking authority, and especially why are we talking about FTC rulemaking authority when it comes to unfair method of competition. So there's a case for this so-called rulemaking now, and it's very reinvigorated those days in DC. Marina, can you just tell us about why we have this argument for rulemaking when it comes to unfair method of competition?
Sure. Is this mic? Yeah, it's working. So I thought, since I'm the first speaker on the panel, before I specifically address the question that you've asked, let me just spend a minute to talk about the relative roles of the FTC and Congress to sort of provide a context for this panel discussion. Statutes typically begin as broad statements of principle. And then over time, these broad statements of principle tend to take on more particularized meaning through agency adjudications and rulemakings and court decisions with contribution from scholarly research. In the case of the FTC and Congress, however, the agency's role historically has been a little bit more limited on the competition side in terms of providing particularized meaning for UMC, unfair method of competition. Now, it could be because that at the time there was already Sherman Act Section 1, which was interpreted very flexibly, and so maybe Section 5 was seen as a little bit redundant. Maybe, I'm not sure. But whatever the case may be, in Section 5 litigation, competition litigation, courts have generally decided cases under Sherman Act theory and Sherman Act standards. And they have rarely looked to the FTC for separate understanding of UMC that is apart from the Sherman Act. And even in adjudications, the commissioner has generally followed the court's lead and have stayed within the Sherman Act boundaries. As to rulemaking, we all probably know that the FTC has engaged in competition rulemaking exactly once. Now, I know that we have a huge debate as to whether there's authority or not, and my point is not to go into the debate at this time. Simply, I'm just stating the fact that the FTC hasn't had a chance to shape competition law through rulemaking. So in short, I think the commission hasn't really taken on the typical role of an agency in giving meaning to important general terms in an enabling statute. So in this case, unfair methods of competition. There's little Section 5 competition law apart from the Sherman Act. So if Congress passes the new bill that is now considering, I suspect that might change because there's so many vague terms that need to be given meaning. So with that said, let me just return to Aurélien's question at the outset, and that is why the growing interest in competition rulemaking after decades of inaction? Why now? Okay, I think there are two general reasons, two main reasons. One is just a renewed interest in Section 5 itself, an interest in using it to supplement the Sherman Act as Congress had originally intended. Now, I think there is a growing sense that something is amiss with antitrust, that is just not doing enough to deal with concentration or with market power in some sectors. And people who are saying that are not just the new Brandeis people, but rather traditional reformers, that something is wrong, that antitrust has become overly focused on false positives and not focused enough on false negatives. That some antitrust doctrines, especially those dealing with exclusionary conduct, that is dominant firm conduct, has been construed a little bit too narrowly, like refusal to deal, exclusive dealing, and so forth. And since Congress clearly passed Section 5 of the FTC Act to be more expansive and to be broader than the Sherman Act, it's logical that if you're not happy with the way that the antitrust is going, that you would look to Section 5 for a path forward. Now, as to why specifically rulemaking, why not just adjudication, right? And I think that administrative law scholars like Dick have long discussed the relative benefits of rulemaking and adjudication in an agency's implementation of law and policy. And Chair Khan has summarized those relative benefits in her co-authored article with Commissioner Chopra, former Commissioner Chopra. I'm not going to go into those specific reasons, but I'll just focus and expand on a couple of themes that, to me, have the most resonance for the FTC. And the first is that rulemaking can allow the FTC to make better use of its expertise and its various powers. I think some people who are not that familiar with the FTC do not realize how much power the FTC actually has. It has the power to conduct market studies, to conduct investigations, to collect a lot of data that they can then aggregate, conduct hearings, perform empirical and policy work, and so forth. So with all this power and with this expertise, it can really rely on the institutional advantage that is provided by these things, okay? To formulate administrable rules to help implement this UMC mandate in a way that's harder to do through litigation alone. And if it's done well, I think rules can be used to operationalize the rule of reason standard that's become more and more cumbersome in recent years. And I don't know if Andy is still here. Well, that I think I'm pointing to something that Randy had, Andy had said earlier, and that is, I understand that this is a little bit of a workaround, right? I'm saying that something about antitrust is not working too well. The rule of reason has become too cumbersome. The overcautiousness and the emphasis on false positives have made it too difficult to actually apply the rule of reason and win. You can win. You can win activists. You can win McWayne. But do we have the resources to win a lot of these cases? So I understand, and I do acknowledge that what I'm suggesting may be a workaround. So another point that has been raised, and I'm not sure where I stand on this, is that it can also be helpful in dealing with competition issues in digital platform and other complex technology markets. There's already a body of literature out there suggesting that ex post enforcement under current antitrust law cannot really adequately address competition issues in these markets because of some of the unique features of these markets, like features like network effects, economies of scope, economies of scale, switching costs, the importance of data and the inherent data advantage of the incumbents and so forth. That all of these together tend to tip tip the market to a winner. And basically it may change the theories of exclusion. And so what I think rulemaking can do is that rulemaking can be can be a way to funnel these insights, these other leading research and empirical evidence and so forth into formulating rules that can work, which can help address the competition problems that may be too large to be dealt with through case-by-case enforcement actions alone. Incidentally, people who've made these observations are not all New Brandeis folks, but they do include some of the rather traditional antitrust economists. I guess the name that springs to mind would be Jason Furman because of the Furman report that he authors, but there are others as well. So the second argument, the only other argument I'll talk about is the other compelling argument is that competition rulemaking, especially in very complex cases, will reduce the costs. That case-by-case litigation and adjudication is very expensive, it's very slow, and it's very burdensome. As I said earlier, how many McWayne cases can you bring? How many activist cases can you bring? So of course, I realize that today promulgating a rule, a notice and comment rule, is quite time-consuming and is quite costly and burdensome upfront. But once a rule is issued and once it survives judicial review, then adjudications and decisions later on would be manageable and would be more efficient because the use of experts can be reduced quite a bit. So I think they can be best used when there's a high stakes issue and when it's an issue that recurs time and again. In that case, rulemaking has distinct merits. Now, of course, all of my discussion about the merits presupposes that there's authority. And I'm not going to go into authority right now, but of course, without legal authority, the FTC cannot issue UMC rules, no matter how beneficial rulemaking may be from a policy perspective, as I think it is from a policy perspective.
Yeah, Thank you so much, Marina. I think it's a great way to kick off the discussion, and it's interesting that you mentioned the Furman report in the UK, which promoted this idea of ex-ante rules, but also the Kramer report in the EU with the Digital Market Act, and all these reports have this idea of ex-ante rules as opposed to ex-post rules. And to echo the previous panel, there are rules, but the question is which rules, adjudications or regulations. I think once that we see the rationales of ex-ante rules because of quicker and a more expedite way of regulating businesses with some unintended consequence potentially. Now it's interesting to move to Richard and to discuss precisely what you left, Marina, is the legal authority. What about the legal authority of the Federal Trade Commission to issue rulemaking, to issue rules when it comes to unfair method of competition? Dick?
So let me begin by just introducing what I think my role on this panel and in this conference is. I've been teaching antitrust law for 45 years, so I'm not totally ignorant of the field, but I don't have the kind of detailed understanding of all the cases and the history of the field that any of the other participants have. So what do I have to offer? Well, I have a very good understanding of administrative law, and in my experience, neither the leaders of the FTC nor the members of the FTC bar tend to have a real good understanding of administrative law. So I want to start by just giving an administrative law perspective on what we're talking about. And the starting point here is there are three kinds of rules. There are policy statements, there are interpretative rules, and then there are substantive rules. What prior speakers have referred to as guidances are some combination of interpretative rules and policy statements. Okay, an interpretative rule is just a rule that announces the agency's interpretation of a statute it administers, and policy statement is just a statement of the policies that the agency intends to try to further in its implementation of the statutes that it implements. Those kinds of rules have one big disadvantage that I'll turn back to in a moment. They are not legally binding, okay? But they have some enormous advantages. First, they can be issued relatively quickly. You need to provide an explanation for why you've done what you have done, but you don't. There's no prescribed procedure, so it's not the very long resource-intensive process that's involved in issuing a substantive rule. Now, the other disadvantage, however, of policy statements and interpretative rules or guidance documents, if you prefer that language, is they're incredibly easy for the next administration to change. And in this age of extreme political polarity, you can be quite sure that just as the current FTC in the first 2 weeks of Chair Khan's running of the agency eliminated a whole lot of the prior guidance documents. If we have next a Republican president, there's a good chance that all the high proportion of the guidance documents or interpretative rules and policy statements that are issued in this administration will turn out to have quite short lives. Policy statements and interpretative rules or guidance documents can be extremely valuable, and the FTC has used them to great effect if they are coupled with strategically chosen adjudications. If you say, okay, our interpretation of the statute is this conduct is illegal, and our policy is we want to eliminate this conduct, then people can ignore those non-legally binding statements unless and until you bring a couple of successful enforcement actions and hurt some firms that have engaged in that practice. But if you couple the guidance documents with strategically chosen adjudications, they can be very effective. Now, that's completely different from substantive rules in many respects. Substantive rules cannot be issued except through use of the notice and comment process. The notice and comment process takes an average of somewhere between 2 and 5 years to complete in any given case and is extremely resource intensive. The big advantage it has is it creates a legally binding rule of conduct. So that's a big advantage. Another big advantage is it's more sticky in the sense that the next administration really would have to work very hard and long to change it. But the disadvantages are, takes a lot of resources, takes a lot of time. Other characteristics, and I don't call them either advantages or disadvantages. I actually think of them as advantages, but they're the current chair might experience them as disadvantages. These are taken very seriously by reviewing courts, and reviewing courts want to see solid empirical support for any rule you issue using the notice and comment process. So you gotta follow the very demanding, lengthy, burdensome procedures. And at the end of the day, you better have lots of empirical support for whatever you say. But if you can do that, that's great. Now, one other characteristic that I know we're going to be spending a lot of time on is, while interpretative rules and policy statements, you don't have to point to some provision in a statute to support your power to issue an interpretative rule or a policy statement. All agencies have that inherent power. It would be stupid to have an agency that didn't have the power to announce publicly how it interprets the statutes it's implementing or what policies it plans to pursue in implementing those statutes. But when it comes to substantive rulemaking, you better have solid statutory authority to do it, or you can't do it. Now, there's one other form of rulemaking that actually Howard discussed in his introductory speech today. That is the notice and comment rulemaking, as it was tremendously expanded by Congress in 2 amendments to the FTC Act in 1975 and 1980. And that creates a procedure that is so burdensome that it takes 6 to 8 years to complete a single rulemaking on average, and just a tremendous amount of resources. It's clear that FTC has the power to use that extremely demanding form of rulemaking to create substantive rules to implement the part of the act that makes it unlawful to engage in unfair or deceptive acts or practices. It is not at all clear that they have the power. Well, what Chair Khan argues is that they have the power to use not that very demanding form of rulemaking, but the straight notice and comment version to determine and define the unfair competition practices. And that is highly doubtful, I'd say is the best way to put it. She's relying on the combination of a DC Circuit opinion issued in 1973 using a method of statutory interpretation that no current member of the Supreme Court would find acceptable, and then a very strangely worded few words in the 1975 amendment to the FTC Act. And I wouldn't say she has no chance of prevailing on that, but I think she has very little chance. The FTC has very little chance of prevailing on that. But with that introduction, I think I'll turn back to people who actually have served at the agency in responsible positions and can provide a lot more meat on the bones of that just generalization.
Thank you so much, Dick. That was a very interesting portrayal of the different types of rules. And of course, these policy statement and interpretative rules are easier to adopt and give more freedom. And these very demanding substantive rules is what we're talking about here as the FTC, this kind of legal authority to enact substantive rules when it comes to unfair method of competition. And you're skeptical about that. But the thing is, we were here before. In the past, in the history, there was already some kind of adoptions of substantive rules, and Congress reacted to that. So, Maureen, can you just tell us a bit of these congressional reactions in the past of FTC's attempt to adopt substantive rules when it comes to unfair method of competition?
Yes, thank you. Happy to talk about that. So when the FTC adopted what became known as the Octane Rule, it adopted as both an unfair method of competition and an unfair and deceptive act or practice. And then that was challenged in the DC Circuit and led to the case that Dick referred to, that where the court upheld its authority, though did very little to parse through whether it was an unfair method of competition or an unfair deceptive act or practice. And one of the things to keep in mind when we're talking about rulemaking, the FTC has this incredibly generic statute, unfair deceptive acts or practices in or affecting commerce. It was so easy to be a commissioner because I could recite my basic statutory authority because it fits on the back, it fits in a tweet, right? It's so brief compared to a lot of other highly detailed statutes where agencies undertake rulemaking based on very clear direction from Congress about what they're supposed to be doing. So in response to the petroleum marketers case on the Octane Rule, Congress 2 years later enacted the Magnuson-Moss Act, which imposed very detailed rulemaking procedures for the FTC to engage in unfair and deceptive, so just the consumer protection type of rulemaking. It put additional statutory requirements in, notice requirements in, hearing requirements in, and also gave the FTC the ability to enforce the rules, because that's another thing that's kind of missing from this general authority in the FTC Act. It's not clear that the Act under the previous authority actually gave the FTC the ability to enforce or impose any remedy for a violation of the rule. So Congress stepped in with Mag-Moss and put all these highly detailed guardrails in place for the FTC. The FTC then went on a rulemaking spree. I wasn't here for this morning, but I wonder if that's what Howard may have talked about. And then they ended up with even more requirements on it and a definition of unfairness for the first time. Kind of putting that all to one side, because the real debate going on these days is what happened to that unfair methods of competition authority that seemed that the court supported and that Congress, in enacting Mag-Moss, essentially was silent on, said this doesn't affect any authority the FTC may have for unfair methods of competition rulemaking. It doesn't say the authority, it says any authority. And I think that sort of agnosticism is important, because Mag-Moss is not the source of UMC rulemaking authority. You'd have to go back to the FTC's organic statute. And as Dick already suggested, statutory interpretation today in the federal courts would be highly unlikely to find that very broad source of rulemaking authority. Essentially, the DC Circuit said, we like rulemaking, we think it's a good idea, we think it carries all these benefits, maybe some of the benefits that Marina touched on, and the statute doesn't say you can't do it. So essentially you can do it. And the AMG decision that the Supreme Court recently issued is just one example of how statutory interpretation has changed. So I don't think there is a source of UMC authority in the FTC Act or in the Mag-Moss Act. But one of the things that I explored, and with my co-author Ben Rawson, who's a colleague of mine at Baker Botts, that's in the volume, is well, whatever happened to the Octane Rule? Right? Where did that go? Right? That was the thing that was being discussed in this case. So we actually went back and looked at the history of that. So Congress decided to adopt the Octane Rule through a statute, the Petroleum Marketing Act, I think it's called. I'm not sure I have it quite, have my little small reading glasses on, but so what happened was the Petroleum Marketing Practices Act, that's the name of it. So Congress adopted that as a law, and it gave the FTC rulemaking authority, but it only adopted it as an unfair or deceptive rule and gave the FTC not just straight up easy peasy notice and comment rulemaking, put additional guardrails in place. The FTC asked for unfair methods of competition authority under that act, and Congress did not give it to it. So I think putting all of those pieces together to suggest that out of a decision that would not be, on very firm ground today, subsequent congressional reaction to put lots of guardrails in place for a broad authority for unfair and deceptive acts or practices, to say nothing in that statute on UMC for the exact rule that was at issue, to make it just an unfair and deceptive acts or practices rule, and deny UMC rulemaking authority, and put additional guardrails in place. And then one other source that I want to talk about is the FTC has rulemaking authority under some other statutes, typically consumer protection statutes, where it has the more streamlined notice and comment rulemaking, things like the Children's Online Privacy Protection Act. But those go back to statutes. They're not coming from the general FTC source of authority, but it's where Congress has made a much more detailed regulatory scheme. And the FTC then is implementing that scheme. And so it engages in notice and comment rulemaking because it's essentially filling in the details. Congress has made the hard decisions. Congress has said, here's where the boundaries are. It's children's online privacy protection. Age 13 is the dividing line. It covers this type of data. Here are the obligations that are required. It's not this kind of very open-ended authority that you see in the FTC Act. So I think when you put all those pieces together, it's a very, very difficult argument to say that somehow out of all of this emerges the ability for the FTC to engage in unfair methods of competition rulemaking authority using simply notice and comment, or really any unfair methods of competition rulemaking. And that's also putting to the side the questions of, if it is this very broad authority, which has been interpreted as to essentially be coterminous with the Sherman Act, what does that mean for a system where we have dual antitrust enforcement and the DOJ has no similar powers? So I'll stop there, but I think that's kind of sums up the congressional reaction.
Thank you so much, Maureen. That's a very clear explanation of perhaps the lack of legal authority, as Section 6G is very opaque and vague. And as you said, Congress refused, or at least denied, to act and recognize rulemaking authority when it comes to unfair methods of competition, and put guardrails for consumer protection rulemaking. Precisely moving on consumer protection aspect, I think it would be great, Alden, if you can walk us through this idea of perhaps using Section 18 and MAGMO's procedure in order to do unfair method of competition rulemaking of some sort. Can you just tell us about these potential limitations or institutional constraints that the current FTC chair may potentially face?
Well, thanks, Aurélien. Glad to do it. I would just add before starting, I certainly agree with Maureen Ohlhausen's commentary on 6G authority. She has written about that with Jim Rill. I've written an article which is in the book collection. So let's proceed under the assumption, which is my strong assumption, that if it ever got to the Supreme Court, I think it's almost certain the Supreme Court would hold the FTC does not have substantive 6G authority. But again, let's look at Section 18. which what does it say specifically? And, Howard Beals discussed it a bit, but it says the FTC has authority, quote, to prescribe rules which define with specificity acts or practices which are unfair or deceptive acts or practices in or affecting commerce. It requires the FTC rulemaking proceedings provide an opportunity for informal hearings at which interested parties are accorded limited rights of cross-examination. And again, before commencing a Section 18 rulemaking, the FTC must have reason to believe that the practices to be addressed by the rulemaking are, quote, prevalent, close quote, and that's the statutory requirement. Now, the FTC policy statement on deception, which was issued in 1983, I don't think is really relevant to competition issues. It says the FTC will find deception if there is a representation, omission, or practice that is likely to mislead the consumer acting reasonably in the circumstances to the consumer's detriment. Unfairness is a better fit. Here you're saying that really misleading the consumer, one maybe could come up with scenarios that basically it doesn't seem like the sort of thing that would really fit unfair methods of competition, harms to the competitive process in general. So unfairness would be a better fit. So the unfairness wing. What about unfairness? Section 5N of the FTC Act, which was promulgated in the late 1980s, states that to be unfair, an act or practice must be likely to cause substantial injury, which is not reasonably avoidable by consumers themselves and not outweighed by countervailing benefits to consumers or to competition. In practice, this is the cost-benefit test. You have to say not only is there substantial harm, but it's not outweighed by countervailing benefits. And that's not easy. You have to do a cost-benefit analysis, like it or not. So there were steps in 1980 added to Magnuson-Moss, to sort of deal with issues raised by some of the rulemakings of the FTC in the late 1970s. Now, the FTC voted 3-2 in July 2021, and this was referred to earlier, to quote unquote streamline the Magnuson-Moss process, remove quote decades of self-imposed red tape, and allow FTC to issue timely rules on a wide variety of issues, particularly privacy. But there were two dissenters who warned that this might suggest stacking the deck and a certain lack of due process. And when 2 of the 5 commissioners write this, you can be sure that reviewing judges, if they're concerned about how a rulemaking was conducted, are going to be very attentive. So I think that should be a warning. You'd have to, the FTC, like it or not, is going to be very careful not to cut procedural corners. Now, the key steps in Section 18, again, it is lengthy, although it can be done. There's a publication of advance notice of proposed rulemaking, which has to include possible regulatory alternatives. There's a notice of public rulemaking for comments with a text of the rule, justifications, alternatives, a preliminary regulatory cost benefit analysis, and reason to believe practices are prevalent. 3, any interested person may seek informal hearings with rebuttal and cross-examination. FTC publishes then the final rule with statement of basis and purpose, prevalence, practices, and it has the economic effect, which gets back to this cost-benefit analysis. And any person may seek DC Circuit review in addition to traditional Administrative Procedure Act grounds. The court may direct the FTC to consider more submissions, set aside a rule based on lack of substantial evidence, and set aside a rule if the FTC's rebuttal or cross-examination precluded disclosure of material facts. And now in enforcing the rule, the FTC may seek penalties over $46,000 per violation and or consumer redress in district court, but the FTC must show the violated a rule with actual knowledge or knowledge fairly implied. So these are tough hurdles because they offer up a number of ways in which critics of the rule could try to get an appeals court say, look, you didn't follow through. There's lack of substantial evidence. There's lack of cost benefit analysis, et cetera. Jessica Rich, who's a former senior official in the Bureau of Consumer Protection, now in private practice, admittedly has said this is a long and rocky road, especially for complex rules with many mandates and for controversial matters. Now, as again, getting back to this Section 5N cost benefit analysis. So the FTC would have to show actual consumer injury stemming from a condemned type of conduct, plus explore plausible claims advance of countervailing benefits. And you can bet that the parties would raise such claims to consumers or competitive process, and it would have to demonstrate convincingly again, the conduct's benefits were less weighty than the harms. And so I think all of this makes it very tough to win on appeal. Not impossible, but tough. And also, there's also the possibility, the court might say, well, wait a second. If this is really anti-competitive practice you're looking at, we construe the term unfair or deceptive acts or practices. Even if you're talking about unfairness, this really applies to consumer protection issues, not competition issues. So that's another risk, I think, might arise on appeal. And I mentioned the due process risk based on what the FTC did a year ago. So taken together, these factors suggest, yes, the FTC could promulgate, I think, an unfairness rule if it was very careful, jumped through all the hoops, made good findings, and so forth. But it would be very hard. And I am going to address one possible such rule later on.
All right, thank you so much, Alden. So this was a very detailed account on Section 18. And so what we understand is that perhaps the legal case for UMC rulemaking under Section 6 is pretty weak, as Maureen described, and under Section 18, it's very, as you said, long and rocky road, like uncertain and quite weak too. Nevertheless, let's assuming, I mean, if you look at the regulatory priority agenda issued by the FTC in November 2021, clearly rulemaking authority and is at the top of the priority. So the current leaderships wants to do rulemaking, irrespective perhaps of the legal discussions that we just had. Marina, given this institutional constraint that we just touched upon, and the willingness of the current leadership to engage in rulemaking, what would be the best use or the good use of rulemaking authority under UMC, more specifically when it comes to, for example, blanket prohibitions? Should it be rulemaking for blanket prohibitions, or should it be rulemaking for, let's say, presumptions or burden shifting, as we discussed in the previous panel? What's your take on the content on the rulemaking, let's say?
Since I'm the only person on the panel who believes that there's 6G authority, I hope you will give me half a minute to try to make my best case as to why I think there's 6G authority, even though it may be a little bit tenuous. I think, first of all, when the legislative history is unclear, is vague, you look at the plain language, right? So if you look at 6G, the plain language of 6G expressly authorizes the FTC to make rules and regulations for the purpose of carrying out Section 5 and then other listed provisions of the Act. Notably, there's no limitation in the language restricting it to procedural rules. And I did not do exhaustive research, but I happen to know of at least one statute, Title 7 of the Civil Rights Act, and at least one agency, the EEOC, where Congress wanted to limit the agency's rulemaking authority to procedural regulations only. And it knew to do that. It knew to spell it out. So in this case, it obviously did not spell it out in 6G. And given the ambiguity, I would say that maybe it's tenuous, but you could make a case that there is authority. Okay. Now, I won't go into a long discussion of national petroleum because we've already talked about that. I would say that it's defensible. On MACMOS, my take on it differs a little bit from Maureen's. So Congress had passed MACMOS in reaction to National Petroleum. National Petroleum said that there was rulemaking authority, substantive and procedural. MACMOS then heightened the procedural requirements for the consumer protection aspect, UDAP rulemaking. But then it specifically said, it is true in one short sentence, that the section did not reach UMC rulemaking. So the way I read it, and I think it is a reasonable way to read it, is that that means that National Petroleum's holding with respect to UMC stands, that it remains intact, right? Because you have a statute that was responding to the case, and it responded to one of it, and it said that we will heighten the procedural requirements for consumer protection rulemaking, but it's not going to apply to UMC. So the way I read it is that the case holds, that the case remains intact with respect to what MACMOS did not alter. And so the commission does have notice and comment UMC rulemaking under Section G. So I had to get that in. Now I'll go back to the question that you had asked. I think a lot of the criticism about the FTC's potential use of rulemaking seems to anticipate that the commission is going to issue across the board per se rules for conduct to which courts currently apply the rule of reason. Now, if that is indeed what the FTC leadership is envisioning, then I would agree that it would be problematic. And those rules would probably be, would not survive judicial review. But rulemaking isn't confined to issuing per se rules, which is the question you had asked. It can involve establishing presumptions of illegality for certain conduct, and then setting the conditions and setting forth the conditions of the criteria, which, if they are met or if they exist, would then trigger the presumption. So this would effectively operationalize it, I think, as I said earlier, the rule of reason, and make it more workable, make it manageable, make it administrable, and yet at the same time would not invoke the per se rule. Mm-hmm. And it would also allow the defendant to then rebut the presumption in the shortened and the abbreviated adjudication. So I'm going to use one example, and that's the pay for delay example, the pay for delay instances. As probably all of you know, the Supreme Court in Activist held that the rule of reason, not per se rule, would apply to reverse settlement agreements. Now, given that, the FTC can't just issue a rule declaring reverse settlement agreements to be per se unlawful, no matter how wrong they think the decision was, right? I don't think that can be done. But what the agency could do is to pass a rule to structure the rule of reason in a way that makes enforcement possible, and to make it more efficient. The commission, it so happens, has had a lot of experience with reverse settlement agreements. And they have actually accumulated a lot of data and a lot of empirical evidence as well. So it's really well situated to know under what circumstances a reverse settlement is most likely to be an improper agreement to pay for delayed entry, no matter how that agreement is disguised as something legitimate, because it has the data, it has the expertise. So if that's the case, then what the rule can do is to set forth the conditions. If you see this, if you see this, if you see that, then if all these conditions are satisfied, if you see the existence of these conditions, then it's going to trigger a rebuttable presumption that the agreement is unlawful, that it's really a pay for delay agreement and not to exchange for a bunch of services and a bunch of products that the generic company is supposedly paying the branding company for. So I think that would be something that would be a very good use of rulemaking. It would involve an issue that has a lot at stake, right? We're talking about a lot of money. A lot of consumers would be hurt if you have pay for delay agreements. And it's an issue that's going to come up again and again. it's something that's very expensive to sue. Yes, the FTC won activists, but how is the government going to win many of these cases, given the amount of work that has to go in to tease out the deal, to show that the payment is really for delay and not for all these, excuse me, bogus reasons for supposedly the payment, right? So, I think that just makes a nice case for rulemaking. But I think it's not even necessary for the agency to have actual experience and expertise. In that case, it happens to have. And so I think it's a very good fit. Even if the government did not, even if the FTC did not have the expertise, if the stakes are high, and if the issue is going to happen over and over again, such as with non-compete clauses, if that's the case, the agency can acquire expertise. It can take advantage of the various powers that it does have under 6B and other, mostly 6B, I think. And then it can take advantage of all the powers that it does have, collect data, acquire new learning, acquire new economic learning, get empirical evidence and so forth. And that I think would be a good use. And I think I'll leave it at that.
Yeah. Okay, so that would be more evidentiary rules, right? Rules of evidence of what is the standard of proof, and that's what you see as rulemaking on unfair method of competition, right? Yeah. Rules of evidence of standard of proof.
Yeah. Yes.
Like rebuttal of.
Right. So what I'm hoping for is that there'll be enough evidence, enough data to allow the FTC to say that when you see this, when you see this, when you see this, then it is more likely than not that there is an anti-competitive effect.
Right.
And therefore, we're going to presume that. And in each particular case, the FTC would not have to go through a laborious process of having experts testify why this particular practice would have a net anti-competitive.
Right. Okay, great. So that's one way of looking at rules, but more specifically, the FTC has looked, or at least envisaged, more rulemaking authority on specific topics. And one of the topics that is discussed and that is very important for every worker, perhaps here in America, is the way you regulate, or the way the FTC may intervene into employment contract and how to prohibit potentially non-compete clause. This is one of the very important issue that I think the FTC is very keen to embark on. Alden, what a kind of rulemaking intervention for the FTC into non-compete clause would look like? Would it be desirable? And what would be the consequences, or perhaps also the unintended consequences of such a rule on non-compete clause?
Well, yes. Thanks again, Aurélien. I think, again, I'm not going to address Section 6G. As I said earlier, I don't think that would really work well. And obviously, the special statutes, which prescribes particular types of rules and rulemaking, such as on children's online privacy, they're inapplicable. So again, we're back to Section 18. Now, non-compete agreements have been used in a wide variety of employment contracts throughout history in the US. Their legal status has been governed by state laws that differ in approach from total prohibition to case-by-case evaluation of reasonableness. And indeed, in recent years, I think a number of states have more and more adopted a tough approach, close to per se illegality, so to speak, towards non-competes, but not all have. Now, there's a solid federalism argument to allow continued competition and experimentation among the states in this area. And the FTC at times has wanted to say it has preemptive authority, rulemaking authority. That's subject to some doubt, but setting that aside, there's a countervailing argument that labor mobility supports a national rule. Now, federal legislation to establish such a rule is certainly a possibility, but it could be hard to pass given concerns that non-competes may serve a valuable economic purpose in many cases. And I'll touch upon that in a moment. Now, an FTC rule is an alternative possibility. The 2021 President Biden executive order on competition in effect, sort of directs the FTC to consider promulgating such a rule. Now, could it succeed? Under Section 18. So consider a Section 18 rule that forbade certain types of non-compete agreements under which, again, an employer requires that the employee agree not to seek future employment with a competitor as unfair acts. So the FTC would be required, again, under unfairness, Section 5N, to account for the benefits of non-compete clauses for consumers and a competitive process, which include reduced cost or better quality for companies, ability to invest in training and with knowledge that they'll be able to count on that training, for example, over time. Now, although some evidence shows that wages are lower with the presence of non-compete agreements, this evidence is not universal, and there may well be company level pro-competitive and pro-consumer benefits stemming from non-compete agreements that outweigh the effect of lower wages. Now, the benefits may involve, for example, protection of trade secrets, investments by company in human capital, concerns about free riding on specialized training of employees. So one might say, okay, why not look at a very narrow non-compete clause directed just to minimum wage employees? Say, there the argument would be it may be much harder to conjure up true efficiency, so they may seem pretextual. So I think certainly if it wanted to act initially, the FTC would probably be on stronger ground in terms of cost-benefit analysis in just considering focusing on such sort of minimum wage employees. Now, although a broad non-compete rule, a broader one, I think, applying to all companies, including highly specialized workers, would probably fail on cost-benefit grounds. There also may be, even for broader non-competes, a targeted rule that could pass muster. Not certain, but possible, which would require an employer to notify its employees of a non-compete agreement before they accept a job. Now, why would that pass muster? That's a situation an economist call one of asymmetric information. Typically, many consumers might not have seen the small print. There could be substantial injury to the consumer, unreasonableness of avoidance of harm by the consumer, and possible benefits for the consumer competition if they're aware. So substantial injury, when an employee is asked to sign a non-compete agreement, is notified about the existence of the agreement only after accepting a job. Individual isn't able to assess the economic reality of the employment situation with all available information. Avoidance of harm when a non-compete is presented after employment has begun and as a condition of continued employment, new employees face a substantial loss of bargaining power compared to their pre-employment situation. They have to choose between their pre-negotiated salary and benefits as compared to the reasonable expectations they had, or unemployment. So at this point, many employees may be unable to negotiate a salary increase. They've lost its bargaining power potentially. Now, the benefits to consumers as employees or to competition, again, there's some evidence that lower wages and worse wage outcomes when there's increased training, strangely enough, over time for workers who are bound by non-competes, and a small amount of evidence that non-competes may have a chilling effect on competition for workers. So I think a defensible rule then would be one that for non-compete agreement to be fair, the employer must offer the non-compete agreement before when the employment contract is signed. And one example might be a statute passed in Massachusetts in 2018, which provides that the non-compete must be provided to the employee the earlier of a formal offer of employment or 10 days before employment starts. Again, as we've seen, this is a tough, Section 18 is a tough road to follow. But if the FTC, again, wanted to look at non-competes, I think they should look at the easiest thing to do would be look at requiring offers that the existence of non-compete non-compete be made before the job is entered into, and to give the employee alternatives. And again, possibly non-competes applying to minimum wage workers.
Mm. Yeah, thank you so much, Alden. That's a very important topic. I'm sure we're going to discuss that this issue of non-competes throughout the year. There's also a federal questions of whether the federal government should intervene in something that is nowadays regulated by states. Another aspect that is perhaps subject to rulemaking authority by the current FTC leadership is the way companies can exclude and have exclusionary conduct vis-a-vis third-party business sellers and other trading partners. And so this idea of rulemaking on exclusionary contract is developing. I mean, we've seen some petition that I think was last year. Maureen, how would a rulemaking on exclusionary contract would look like? Is it desirable? What would it mean in terms of regulating ex ante this type of exclusionary contract, as opposed to nowadays like exposed through the court system?
Well, this is an area where there is already a very well developed body of case law under traditional antitrust law. And at least the petition from Open Markets Institute, which, as you will recall, was where Chair Khan came from before she came to the FTC. Well, at least she worked there a while before working in Congress, has this petition for the FTC to engage in rulemaking, which Chair Khan has highlighted and asked for comments on. So it seems that it has at least some level of interest at the FTC. And it advocates to have rules in place that depart quite substantially from that well-developed body of case law. So it would require or suggest that there should be per se illegality for any exclusivity requirements that result in a finding of substantial foreclosure. And then the test it puts forward for substantial foreclosure is whether a defendant has 30% or higher market share and uses exclusivity with all of its customers, suppliers, or distributors of an essential input, or it results in a 30% or more of the market foreclosed to rivals, or it results in the largest 3 or more customers, distributors, or suppliers being foreclosed to rivals. So it deems that, it talks about the dominance test, quantitative, and then qualitative foreclosure. So these level of market shares are well below what case law has determined for finding concerns about exclusivity or market dominance. So 30% would be on the very low side. One of the most important things about this also is it makes it a per se rule, right? So unlike the case law, which is a rule of reason approach, an entity charged under a rule as at least encouraged by the Open Markets petition, wouldn't be able to put forth actual effects, right? Does this actually do something bad? Or pro-competitive benefits, right? That it actually, we know a lot about, some of the economics here. It's not that it's always good. Like I supported the McWane case. There was no evidence of pro-competitive benefit there, but often what the case law has recognized is that this can sharpen competition, this can be pro-competitive. So that petition is pending before the FTC, and if a rule were to be pursued along those lines, it would again divert quite substantially from the case law. And then interestingly, because I also mentioned this, for industries that are not regulated by the FTC. So the FTC has carve-outs to its authority. It has no authority over common carriers, right? And that's kind of a large bucket, but we'll put that there. They would not be subject to such rules because the FTC couldn't reach them. So you would end up also with this very odd situation where some entities, it would be per se illegal, and for other entities, exactly the same type of behavior would be treated under the rule of reason. And you can imagine, the FTC and DOJ share antitrust oversight. So whether your behavior or even your merger, depending on, how they're going to do these reviews, which agency it gets cleared to could actually affect liability, right? Which is not the situation that we have today, where you have two agencies, they may divide up based on who has authority over what industry or expertise in a particular industry, but they're applying the same standard of liability. So with a rule like that, you would end up in a very different type of area that I think raises some real concerns about having that dual review system that we have.
Right. Yeah, definitely is per se illegality on exclusionary contract when you have 30% of market share. This reminds me of a kind of abuse of dominant position, which is the European competition law. And it's also what Chair Khan has advocated in the House report when she, not only her, but others advocated for a kind of abuse of dominant position in the US for a Europeanization of antitrust, where you will have more aggressive enforcement. So that would be a very radical shift and some departure also from the DOJ, as you just mentioned. Having heard all that, this potential very ambitious agenda and very potentially aggressive or at least ambitious agenda on rulemaking, Dick, in terms of the reaction to the court and in terms of the potential assessment of this rulemaking agenda in the months and years to come, what is your analysis of that? How do you see that faring in the midterm or long term?
Thanks. Let me just begin with a very brief response to Marina's case in support of the existence of the rulemaking power. I think she made the strongest possible case and made it very well. And if I were representing the FTC, I would have no problem at all going before the US Supreme Court and making exactly that argument with a straight face. However, I would have cautioned my boss, the chair, that I thought we had only about a 30% chance of success, because I just wrote up the two most recent administrative law decisions that the US Supreme Court issued last week. And in both cases, all 9 justices placed a tremendous amount of emphasis on context and consistency. And both of those are big weaknesses that can be pointed out, would be pointed out by opposing counsel in response to Marina's argument. But let's assume that FTC prevails, and I'm not saying that can't prevail. There's a chance they'll prevail on that. When I read Chair Khan's writings, I see that what she wants to do with rulemaking is, she makes it very clear, she wants to change antitrust law. And she's gone into quite detail in criticizing a lot of the Supreme Court's opinions in the area of antitrust law. So she apparently believes that, assuming she has this power, that the agency has this power, the agency can use it to say, okay, the Supreme Court said X about this practice, we say not X, and we win because we did it by rulemaking. And that has zero chance, absolutely zero chance of prevailing in the Supreme Court. The fact that this statute is worded a little bit differently from the Clayton Act or the Sherman Act, or they use rulemaking rather than, the justices aren't going to pay any attention to that. If the agencies goes up there and says, you're wrong and we're right, now accept our position, they lose every time. That's 9-0 losses. Now, and I make that point in the piece, my contribution to the book in a few contexts. But Marina's discussion of a potential reverse payments rule is a really intriguing illustration of something that could work if FTC has this power. Justice Breyer's opinion for the majority in Octavus says, okay, we're not going to accept, I don't accept the position of the FTC that there should be a presumption of illegality with respect to reverse payment settlements. But what I see is rule of reason, and I don't think rule of reason is going to take very long to address because it's pretty easy to address this. But we now know, and FTC certainly knows, based on painful experiences in the post-Octavus period, that we're now talking about 10 to 15 years to apply rule of reason. And the result in many cases after 10 or 15 years is, yeah, it was nothing but a thinly disguised agreement to create a monopoly and share monopoly profits. But in the meantime, there's been 10 or 15 years that deal is. So I could imagine if it's real well, cleverly worded to pick up on the language of the majority opinion in Octavus, rather than saying the court was wrong, saying the court was right, but now we have some pretty solid evidence that it needs to be structured in order to, I could see that potentially having convincing the court. One other point there, though, that was the opinion of Justice Breyer on behalf of 5 justices who are not there anymore. And there were 4 justices who wrote a dissenting opinion saying, no, absolutely not. There's a presumption of legality. And frankly, there are now 6 justices who share the general philosophy of the 4 justices who said, no possibility. So there again, I give only a fighting chance of that surviving judicial review.
Could I just
Sure.
add one point on that? So I think the FTC really missed a great opportunity post, and I happen to say activist, so who knows how it's really said. There must be a real name somewhere that's source of truth, exactly how it's said. But the FTC did not pursue enforcement cases in its Part 3 authority after it won that big victory, because it wanted to pursue money through its 13B authority. And we saw what happened with that eventually in the AMG case. So my speech that was cited in the AMG case called Dollars, Doctrine, and Damage Control, how the FTC pursuit of disgorgement affected its antitrust mission. I think it was a huge missed opportunity. Had it brought these cases in Part 3, it could have done the things that, Marina, I think you're absolutely right. It could have established a much more clarity about what is a payment, what are the indicia of it being a sham kind of payment. So kind of seeing all these things interrelated, I tend to see this as an example of where FTC overreach and desire to do something that the statute and Congress hadn't really gave them the ability to do, made the agency actually much worse off and consumers worse off, and kind of set back the ability of the FTC to achieve things. And opportunity cost is an enormously important factor that engaging in a lot of rulemaking, I think gets overlooked. The opportunity cost of using the tools that the agency clearly has to address issues.
Alden?
Well, just to add to what Maureen said, I think, again, one of the problems, and the justices may implicitly have realized it, that trying to get 13B consumer redress, there was a strong argument for it in the case of clear fraud. If you can, much easier case to measure, where seller promises X, doesn't deliver it. It maybe not be perfect, but that's something you can measure. That was really the sort of situation that arose in the AMG case, but even there they lost. But the problem with these competition cases is, even if there's an illegal reverse payment, the ability to measure with accuracy consumer loss or excess profits is very difficult. And I think there had been this principle that the FTC had accepted before, that you should have a very clear understanding that you should readily be able with a high degree of accuracy to measure the loss, which means that I think that former Chairman Muris argued that, yeah, the FTC should have stuck, if it had stuck just to clear cases of fraud and so on, but it didn't escape some people's notice that it tried, as Maureen said, to go beyond that and beyond the real capacity of accurate economic measurement.
Right. So before moving to Q&A, I would ask each of the panelists to perhaps give final comments on what you've heard from other panelists, and more perhaps ambitiously, given what we've had as a discussion on the doubt about the legal authority of the FTC rulemaking authority on UMC, what would be your advice to Chair Khan, since the current leadership definitely wants to engage in UMC rulemaking? What would be your advice if you have to advise her and the leadership on what to do when it comes to rulemaking authority? Perhaps I can start with Dick. Yep.
Well, my first advice would be to rely on what the FTC knows it can do in the sense of the tools that it has traditionally used to considerably good effect. The combination of interpretative rules and policy statements and then strategically chosen enforcement actions, I think can get them a very long way. And I don't really see a lot to be gained from taking the chance of trying to persuade the Supreme Court that it has notice and comment power. But whatever else they do, whether they follow that advice or not, I'd urge them to listen very carefully to the views of people like Marina and Andy in the earlier panel, who are very clear that there are problems in antitrust law today. There are very serious problems in antitrust law today, but then there are incremental ways of changing antitrust law that would improve it quite a bit, rather than just going straight into, I hate everything that now exists, I'm now going to reverse it all. That approach can never work. Go for the incremental changes, and then along with that, go for the kinds of changes where you've got very solid empirical support for what you want to do. Really, going back to Alden's point, I mean, you got to have solid evidence in support of whatever change you want to make. So those are the three pieces of advice I'd give.
So non-legally binding rules, enforcement actions, and incremental changes. Marina?
Can I offer non-legal advice? I think maybe one thing is to not be so acrimonious on the commission. I think if you want to have a chance of having a rule or whatever it is to be accepted by the court in review, it's better, even if it can't be 5-0, it should at least be not acrimonious. And then related to that is, I don't think it's necessary for the leadership to go all out and say we want to abandon, scrap the consumer welfare paradigm. I don't think there's going to be a chance of that happening. But the consumer welfare paradigm is pretty elastic. It's really a term of art. So you can be in support of that and still push the boundaries a little bit to consider more things. So this is not really legal advice.
So incremental changes as well.
I guess it's
incremental change. Yeah. Maureen?
I already mentioned opportunity costs, and it seems that the FTC, the leadership at the FTC, is looking in these other directions and away from case-by-case enforcement. We've already heard case-by-case enforcement numbers are way down. Right. But when you look back, the way the FTC has effectively changed antitrust law is through case-by-case enforcement. And the agency has a very good record in the Supreme Court. The activist case, hospital mergers, you have Phoebe Putney, you have North Carolina Dental on state boards, and the list goes on and on. We mentioned the McWane case, which gets, thank you for mentioning it. It seems because it didn't involve a tech company, nobody wants to talk about it. But what has worked in the past the FTC has had a really good record, I think, of doing strong enforcement based on evidence. When you think, both Marina and Dick and Alden mentioned having a good empirical basis. Think about how the FTC for hospital merger enforcement had lost a bunch of cases. DOJ had lost cases. Tim Muris did a very good retrospective and created the basis for changing the court's minds on how this actually was anti-competitive. And that has paid enormous dividends to the agencies and to antitrust and to consumers. So I think, yes, it takes time and, patience to do those kinds of things. But I think the FTC is really created to make that kind of change and, look at what has worked in the past as a path forward.
Right. So save resource and focus on enforcement actions. And this comes back to the FTC being a head to the Department of Justice Antitrust Division at the end of the day. Alden?
Not too much to add. Again, I agree. I think FTC should focus on enforcement actions. I also think that by reinstituting respect for economics and the consumer welfare standard, and perhaps issuing a new interpretive statement of the meaning of unfair methods of competition, it could strengthen its hand, because I think the FTC also, it should be very careful in issuing new interpretations, such as new merger guidelines, because I think if it does not, since the courts for 4 decades have highlighted the importance of consumer welfare standard, which, as Maureen had said, it can be applied more broadly than many people think, the courts are not going to like it if the FTC seems to have abandoned economics and abandoned the consumer welfare standard. I think it really needs to get back to those things. Maybe bring 1 or 2 narrow Magnuson Moss rules, but if it doesn't get back to those things, I think it's really threatening its ability to win in federal courts, because federal court judges will be not unaware of what's happened.
Right. So be aware of the judicial backlash and make sure that it's not counterproductive. So thank you so much for this discussion. We're going to open it up to Q&A. Is there any? Yeah, Bilal.
So this question really touches on something Marina said, and I want to present an alternative to. First, a proposed rule with respect to reverse payments, at least as you describe it, strikes me as mimicking, or would require mimicking, of a rule of reason analysis in an adjudication. So I'm wondering what you get out of a rule that sounds well like you laid out. And then I'd contrast that with an alternative area where I think the agency might actually think about a rule, although they've done something with this, and that's in the area of sort of state action, right? Either articulating what might be active supervision in a rule-based structure, right? It's hard for me to see the parties having an efficiency justification, in a sense, if you can think about it this way, for failing for the active supervision prong to be met. And I think it'd be useful for the agency to articulate this potentially more than they have. Now, the agency has done that. We did that in, I think, the Iowa Movers case back in 2003 or something in the aid to public comment. But I wonder if you can contrast the two. What you propose sounds like a rule of reason analysis, and it doesn't strike me that that's the right approach for a rule. Whereas, defining what's active supervision, and maybe there are others, strikes me as a place where there could be some rule-based framework.
So thank you. The reason I suggested what I suggested for pay-for delay is that there is so much data. We have a lot of empirical data on it. So if you do it just once, so because of all the empirics, you can say that if this amount of money is exchanged and this amount of service is exchanged, well, I don't have I don't have access to all the data, and so it's hard to describe what it is. But you simply do it once. In other words, you are essentially analyzing and processing the aggregated data, and you're then coming up with the rules that say, if you see this, if it's contemporaneous with the agreement to delay entry, and it's never been done before, whatever it is, I can't make up the conditions now, then there would be a presumption, okay? So it can be done in every single case. So then you push the burden onto the defendant, and it's fair because the knowledge is in their position, is in their, they have the information. They can more easily come out and come back and rebut it and say, okay, we did pay this amount, but we got back this, and this. And that is why the presumption does not fit in our case. We have rebutted the presumption. So I think a lot of money can be saved in that regard. And these cases are taking so long, as Dick was mentioning. And by doing that, you can shorten the subsequent cases much more. And I know, I think what you're talking about in state action is right. I think when I was policy director, there was already a policy statement out. Has that policy statement been updated, or is it the same policy statement on what constitutes active supervision? It's still the same.
But it seems to be the questions around what is active supervision. Whereas, you know, what still, and just listening to you on the reverse payments, it just strikes me as a, you know, forcing a rule of reason analysis into a slightly different format. And so it doesn't seem to me, it doesn't seem to get you much. Whereas, you know, in some other areas, at least it may be workable, and it may, you know, may get you more than a policy statement. I mean, a lot of what, as Maureen said on the hospital merger matters, I mean, now, you know, the courts, both the agency and the courts, have a pretty clear framework of how they're thinking about them. That strikes me as, you know, had been developed through the case-by-case analysis, but has now shortened the analysis the same way. I mean, if the agency were bringing reverse payment cases, could happen absent a rule, you know, as you described. So I guess what I'm getting at is a rule seems like a very poor format to accomplish simplifying cases where, in fact, you know, parties may have an efficiency justification or not, or something other than efficiency justification. And I still don't see what you get from it outside of a you know, a policy statement or a, you know, case-by-case adjudication that, you know, eventually the courts accept as a framework.
I actually think it's amazing that I think between them, Marina and Maureen have come up with the solution of a very important antitrust problem. I think these pay-for delay agreements are really quite devastating in their impact on consumers. So I think a statement of the type that Marina was discussing that establishes the framework for decision making, and that incorporates a lot of the solid empirical evidence that the agency has, coupled with Maureen's suggestion that, well, we're not going to try to go for damages. We're going under Section 3. But in a sense, I agree with your point that it doesn't have to be a substantive rule. I think what Marina is talking about could be done in the form of a guidance document, or in administrative law terms, interpretive rule / policy statement. And it wouldn't be legally binding, but it would then tell everybody exactly where FTC plans to go. And then FTC follows that up by applying it or attempting to apply it in a given adjudication. And I think there's a good chance that it would pass muster with the courts and be considered entirely consistent with the Supreme Court's holding and reasoning in Octavius. So I actually think I'd love to see the agency do that soon.
Yes.
Wondering if we might sort of zoom out a little bit to other regulatory agencies, other enforcement bodies, and are there other agencies that have sort of done this rulemaking process either well or really badly that we can learn from? So, for example, Professor Pierce, I know you've done a lot of work in the energy and environment space, and are there lessons to be learned elsewhere for antitrust?
Yeah, the lessons are it's always going to take a long time. It's always going to be resource intensive, and it's always going to require significant empirical support in order to pass muster in court. If you do that, then after 3, 4, 5 years, you usually win. And that's across lots and lots of agencies. Now that's under straight notice and comment. The Magnuson-Moss version of notice and comment, it's a whole different animal, and we don't know very much about how the courts would respond to that after the many years it would take to complete one of those proceedings.
Perhaps one last question, very quick question, if any. No, so then we're good for lunch. Thank you so much. Oh, sorry, there was. Oh yeah.
Just to wrap up on national petroleum refiners, Justice Scalia was always very clear that what matters in interpreting statutes is what would reasonably have been understood at the time by the words in the statute. I'd just love to hear any thoughts you might have about what the Congress of 1914 intended with Section 6G.
Well, I mean, one thing that we saw certainly in the AMG case is, and I think Dick talked about this, is how does this fit in the overall statute, right? You're not going to extract a couple words out and interpret that in a vacuum. And the FTC was, it had these powers under Section 6 to do studies and to do, other things, but its real, one of its key roles was Section 5 case-by-case enforcement. So I think you also need to look at where that rule is situated, because it seems to be a little like detached, I think, from kind of the core thing. And one other point I want to make is everyone talks about petroleum refiners as if it is a Supreme Court case. It is from one circuit, right? So it is not binding in other circuits. It certainly might be instructive in other circuits, but if a challenge were to be done to FTC UMC rulemaking that went up through another circuit, that circuit is in no way bound by the DC Circuit case. And I think sometimes that gets a little bit overlooked.
I agree completely with Maureen on that. I just point out that there's a lot of cases in which the Supreme Court has said, well, we're particularly influenced by an agency interpretation where first it was the interpretation that the agency announced shortly after the statute was enacted, because that's the time when the agency is most likely to know what Congress intended. And second, when it has been the consistent interpretation of the agency. And that's where I get back to, oh, are they in trouble in trying to make this argument in the Supreme Court? Because what the agency said initially was, no, this does not give us the power to issue substantive rules. It only gives us the power to issue procedural rules. And then it said that for what, all the way from 1914 until 1962. And it said it again and again in congressional testimony in many places. And wow, you got a heavy burden to then convince the Supreme Court. Gosh, the first commission had it all wrong. And the commissions that existed all the way from 1914 to 1962 had it all wrong. And all of a sudden the DC Circuit finds this one little reference to rulemaking power buried in the same sentence with power to require reports from corporations. I think that's a really tough argument to prevail on.
On that note, I think that's a great way to close up. Please join me in giving a round of applause to our great panelists. Thank you.